Hello friends, welcome once again to the Supreme Court Historian YouTube channel. It's been a while and I hope that things will improve bandwidth wise for me and we will have videos at a better frequency compared to what it has been over the past couple of weeks. So we are finally now embarking on our right to equality chronology. I've discussed this in the previous video that we will be dealing with the right to equality and the right to life in a slightly different manner as compared to our normal uh, process. The normal process is where we look at one case after the other chronologically, notwithstanding what the subject matter is. But for these two topics in our law, the fundamental right to equality and the fundamental right to life, because these two have expanded or contracted or evolved with time, we will be dealing with them in a manner of a bunch of cases taken together. So we will be starting with Kathi Running Rawat's case, which was decided in February 1952, and it refers to two prior right to equality cases which I have deliberately skipped so that they can be considered together. The prior cases being the December 1950 judgment in the Chiranjit Lal case and the May 1951 judgment in the FN Balsara case. Very important, very interesting cases, very significant, and they really help us understand the concept of equality, because more than any other provision in the constitution, the right to equality enshrined in Article 14 is the one which requires a lot of discussion. It is an extremely confusing provision. It is an extremely self-contradictory concept almost, that there should be equality, but at the same time different people should be treated differently. So this kind of abstract concept really does require a lot of commentary from the judges of the Supreme Court, and fortunately we have been blessed throughout our history by judges really very well equipped to give such commentary and to help us understand the concept, and the judges themselves had been assisted by some very capable lawyers as well. So we will therefore rely a lot on these judgments when we deal with the right to equality. So let's begin first of all with a quick look at what the article actually says. Article 14, its title is Equality Before Law, and the wording is a very simple two-line definition. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. So first of all, it is a duty that is given to the state, which of course is the government at the center, as well as the state governments, as well as the local self-government bodies, whether they are executive or legislative. All of these have this duty to not deny equality before the law to any person. It does not say to any citizen, but it says to any person. The only restriction is the territory of India. The government in India is not responsible for equality in Pakistan, for example, right? You can only restrict yourself to equality in the territory of India. So while it is a very expansive definition in the sense that no person shall be denied equality, but only in the territory of India. Secondly, there are a couple of facets to this. There is equality before the law, and there is the equal protection of the law. So there are two concepts over here. The second is actually really a corollary to the first. The first, that is equality before the law and equal protection of the laws, it's not just a mere singular and plural thing. When we speak of equality before the law, we speak in a more philosophical sense, law as a concept, and protection, equal protection of the laws. When we are saying that, the laws we are referring to are very specific laws, enactments, legislations. That is the very basic difference between the two terms, but we shall delve a little deeper to try and understand what we mean by these. So first of all, equality before the law, that there shall be no special privileges to any individual just because you are a cabinet minister does not mean that you will get to breathe a different kind of air, or that you will have a different set of laws for you. That is not what is allowed. Equality before the law means that every person, notwithstanding their rank or position, is subject to the jurisdiction of the same ordinary courts. If a person has been charged with the commission of an offense, that person shall be tried in the same court as a normal individual is, even if that person is, as I said, a cabinet minister, or an Olympic medalist, or some movie star or something like that. It does not matter. If you have committed an offense, you will be charged and tried before the same courts as any other common person. There will be no special privileges. This is unlike, for example, the United Kingdom, which, as we were recently reminded, is still a kingdom. They have a monarchy, they have an aristocracy, starting from a knight, followed by a baronet, followed by a baron, and a count, and an earl, and so on and so forth. All of these have different rights and privileges. That is not the case in our country. We are a liberal democracy which is governed by the rule of the law, and everybody is equal before the law. Nobody is above the law. That is basically the concept of equality before the law. The second clause, equal protection of the laws, as I said, is a corollary and a more specific look at the concept. This is a guarantee of equal laws. Equal protection shall be secured to all individuals in the enjoyment of their rights or privileges. Everyone has the same rights, and these rights are equally protected by the laws. That is what this concept basically means, that any rights or privileges that I enjoy as a common citizen of the country, or as a common person residing in the territory of India, really, those rights and privileges shall be protected with the same vim and vigor as the rights and privileges of a more connected person are protected, if that explains it. But more importantly, we should also focus on what is not included in equality. It does not mean that there is no classification ever at all. It just means that there shall be no arbitrary classification. Now, I am relying heavily on V.N. Shukla's Constitution of India, which has been revised by M.P. Singh. And this first sentence is taken directly from that book. Equality does not mean same treatment for everyone, but rather same treatment in those respects in which they are similar, and different treatment in those respects in which they are different. So, for example, a physically challenged individual, what we used to call handicapped person, such an individual will definitely by right receive different treatment compared to a healthy individual, right? We expect this to happen. We see that, for example, there is reserved parking for a handicapped person, while the rest of us, we have to park a little farther away from the entrance to a government building, for example, right? So this kind of classification is not prohibited by Article 14, as long as there is some reasonable discrimination that is allowed. I'll give you a more common example, which actually is by definition arbitrary. That is the right to vote. You have to be 18 years in order to be able to vote in any election in our country. Significantly, until the late 1980s, this used to be 21 years, right? So there was a classification, but it has been changed. That, one might say, is the very definition of arbitrary. But the point is that there has to be a reason behind this, that anybody below the age of 18 is more likely to be influenced or to be coerced, unduly influenced or coerced to decide in a particular direction. Whereas as we grow older, as we cross a certain age, usually considered 18, we are expected to be more mature, and we are expected to be able to decide for ourselves in a more reasoned manner. which is why, for example, even an individual who is below the age of 18 cannot enter into a contractual agreement as well, because that person, any such contract is void ab initio by a person who is not 18 years of age. Anybody who commits a crime before they turn 18 are considered a juvenile offender and are treated differently. So these kind of reasonable classifications are not prohibited by Article 14. What we basically in a nutshell are trying to say is that equals must be treated equally. All of us will receive the same water in the as the rest of the people in our city receive. All of us will breathe the same air. All of us are expected to stop at every traffic signal. These are the things that we mean by equality before the law and equal protection of the laws. But there will be specific laws for different categories of individuals. In a previous discussion, we have spoken of, for example, that a woman cannot be arrested in India after sunset and before sunrise. This is discrimination, there is no doubt about it. Or there are reservations for scheduled caste and scheduled tribes. This, one might say, is discrimination, but there are valid reasons behind that. There are large and significant arguments for why this discrimination, one might say, takes place. It is essential in order to protect some other rights, in order to right some certain historic wrongs. So this kind of classification, as I said, is not prohibited by Article 14. So let's stop right now and not make a very long video. In the next video and from the next video onwards, we will look at the specific case that we are dealing with, because after all, we are the Supreme Court Historian channel and we are looking chronologically at the important judgments given by the Supreme Court of India. So Kathirani Rawat's case next time. See you then. Bye bye.